Every parent of a student with special needs should be familiar with what an individualized educational program, or IEP, is. The reason it's so important to know about IEPs is because they enable students with special needs to receive the appropriate educational program and services.
Okay, so on the IEP, there's different sections, along with some demographic information, the student's ID number, one of 13 disability education classifications defined by the federal law, IDA. And it starts off with a section known as present level of performances. And that is kind of like a snapshot where the student is at the time of the meeting. And it's broken down into 4 different areas. One that focuses on academics. And in that section, it may have results of recent evaluations, standardized assessments, such as the Sandy tool for students who are alternately assessed, recent psychological evaluations, standardized tests, notes from the teacher, and an area that has social development, physical development, and management needs. In each section of the present level of performances, which is also known as PLOPs, there's an area known as parental concerns, which is fairly new. The city and state adopted it, I think, within the past 5 years or so. And within that section, parents can have whatever they like to be documented. And we encourage parents to speak up about this at meetings, so there is a paper trail should they go back at a later time and ask for different services, that it could be substantiated by the text being written on the IEP. There could be information about where the child is with their reading skills, writing, math, their independence, their functional skills, again, for kids with developmental disabilities, with more involved needs, who may be in a District 75 setting. There may be information there on their ability to walk in the halls, to get their book bags, to what extent they could use a pen and paper. And I'm just giving very simple examples so you folks get an idea. On other sections, there may be information such as management needs. So if a student needs a break, if a student needs certain accommodations such as a graphic organizer, for information for curriculum to be highlighted, and also if the student needs a behavioral intervention plan, assistive technology, which is any type of technology that the student uses to bridge the work to their environment. For example, my son uses an AAC device. He's mostly nonverbal, so it's a mini iPad that he touches, which produces text to speak. There's also measurable goals, a section that has that, and that could be broken down into either long-term goals or short-term goals. There's also something known as the least restrictive environment statement, which is a statement that justifies the type of setting that the team recommends. The setting could be a program or the school. It's the physical environment in which services and supports and the program is delivered. In addition, there is where the related services are listed. Those are disciplines such as speech therapy, occupational therapy, physical, I told you I was nervous, physical therapy, busing, counseling, and within that section, it identifies the frequency of the service and the grouping and the duration. So an example of that could be if a student is mandated for speech twice a week for 30 minutes, either by themselves or in a group of 2 or more. So in my opinion, of equal value to what they should bring is preparing for the meeting. And so I'll start with what documents people should bring, which is prior to the meeting, if there is a new evaluation that they want the team to consider the recommendations for, submitting that to the team at least 2 to 3 weeks in advance. It doesn't mean, I'm cynical, I'll just say it. It doesn't mean they'll read it, but it's your due diligence to submit that. I want to say there's a caveat with some evaluations that parents submit because there's different service systems, right? So there could be evaluations done independent from the Department of Education that parents want to submit. For example, if they're seeking, a different type of placement, a private school or a funded private school, services for people with developmental disabilities through OPWDD. And I bring this up because those evaluations are done to provide a rationale for a different set of services, and sometimes that could hurt what the parent is asking for at an education meeting. Because sometimes the language could be very harsh in other system evaluations, especially for behavioral supports. And unfortunately, we all know this, I'm stating the obvious, that many people who work in schools, like the rest of the population, have biases. And if somebody sees that a student has an intellectual disability, their expectations may be lower and may influence the team's recommendations. So part of preparing for meetings is reviewing the most current paperwork that a parent has, which could be progress reports, which is basically like a report card for the goals that are on the IEP, any reports by teachers, homework, looking at portfolios, and kind of reviewing what's working, what's not working, what their goals are for the meeting. If they are to bring a spouse or a partner, I think this is really important for parents to work out, as how they'll communicate at the meeting. Parents get emotional, it's scary, and sometimes, the tension is thick and people can argue, which takes the onus off of the team and the Department of Education. So figuring out who's going to speak when is helpful. And in terms of other forms, busing is a big thing, because especially for younger kids, for kids who are transitioning from preschool to school age, for students who may be seeking medical accommodations on the bus for the first time, so limited time travel, air condition, HIPAA forms, things like that.
I want to impress upon you the enormous legal rights that parents are provided under the IDEA. Most parents don't know they have any rights, but they do, and the theory is, under the IDEA, is that if the correct processes are in place to get the important information out about what this particular child needs and what this particular child's unique circumstances are, then the correct substantive result will ensue. That is the IEP itself. So parents have a myriad of legal rights in the decision-making process involved in determining the education program that's appropriate. And again, the key focus is, who is this kid and what services does this child need in order to make meaningful educational progress? And who better than the parent has a particular knowledge of their child? And that's why the parent has enormous legal rights going in preparing the IEP and then securing an appropriate school placement. And the reason, again, is not just because you have particular knowledge about your child, that's enormously important, but you are the child's you have legal responsibility over your child, and so who better can advocate for the best interest of your child than the parent? The parent's legal rights apply at three basic junctures of a child's educational program development: the IEP meeting and following up to the IEP meeting, the school placement where the IEP is to be implemented, and then during the due process proceeding. So I want to talk about the parents' participatory rights in the development of the IEP first. A parent has a right to trigger the whole process. You have a child who's having trouble in school, and the parent, among others, has the right to refer their child for evaluations and an IEP to determine whether they have a disability and are eligible for services. And that request, by the way, just as a tip, needs to be in writing. Once that referral is made by the parent, or if you have a child that's already got an IEP and your child is having trouble in school, you want to ask for your child to be reevaluated, maybe in the middle of the school year, at any time that you think your child is having trouble. Ask for an evaluation in writing, and that triggers a whole set of deadlines that holds the Department of Education accountable to the process of ensuring timely provision of appropriate services. Parents have the right to consent or refuse evaluations and program recommendations. And this is an enormous power in the sense that the Department of Education is not allowed to act unilaterally with respect to your child's education. It is a cooperative model. The parent and the school district, under are, under the law, are required to work together, and the Department of Education must include the parent meaningfully in this process. So therefore, at the juncture of the evaluations, the Department of Education cannot evaluate your child until you, as a parent, I'm referring you collectively as parents, until you consent to those evaluations. You have to, if you disagree with the IEP, you can challenge that IEP, and the Department of Education cannot implement that IEP unless there is agreement or a hearing officer's decision. So consent by the parent is very important. You have the parent has the right to appropriate and sufficiently comprehensive educational evaluations. And it's, after all, the evaluations together with the parents' input and the teachers and educators that make up the important information that goes into an IEP. So educational evaluations serve two functions, important functions. One is to give the parent the information that they need to advocate effectively for their child. The parent knows their child. The evaluation gives them the language and the analysis to talk about and advocate for their child. It allows the parent to exercise their right to meaningful participation in the development of their child's IEP, and gives important information to the IEP team to develop a program that's tailored to the needs of that child. The school district must evaluate the child prior to the initial IEP, and then at least once every 3 years, more often if as needed. If the child experiences a change in circumstance, or is, like I said earlier, is having trouble in school, that could trigger a new evaluation, and the parent has the right to request an evaluation at any of those times. The parent has the right to understand the evaluation. How many times have I had a parent come to me with an evaluation in hand and has no idea what the content of that evaluation is because the Department of Education's evaluator never reviewed it with them? And what's the use of an evaluation if a parent doesn't understand what it says? They have the right under the IDEA to understand what's in that evaluation. If a parent is dissatisfied with and now let me just back up for a moment. A sufficient evaluation under the law is one that addresses the child's areas of the suspected disability in all areas of the suspected disability. That includes academic, social, emotional, and behavioral functioning, not just academic. If a kid is on grade level, if he's getting B's in all of his classes, but he can't navigate across the classroom with socially and behaviorally appropriately, that's a problem with his education, and that he is entitled to have that addressed. If you're dissatisfied with a Department of Education evaluation, you have the right to seek an independent educational evaluation at the cost of at public expense that is paid by the Department of Education. And what would happen there is if it's approved, and you can go to hearing to get it approved, and we'll talk about due process hearings, you will have somebody outside of the Department of Education, oftentimes an independent pediatric neuropsychologist, who will conduct a comprehensive evaluation of your child, will, outside of the lens and purview of the Department of Education per se, and will contain. It will also contain a list of educational recommendations, which you can take as almost like a recipe, if you agree with it, to the IEP meeting for the IEP team to consider. You have the right to examine all records relating to your child in preparation for that IEP meeting, including reports and evaluations that the school district is going to consider at the IEP meeting. And you have the right to receive the documents that the IEP team is planning to consider in a timely fashion before the meeting. It's typical that even if a parent may not even get those documents even at the meeting, but if they do get the documents, they're often provided to them at the meeting. And it's just not possible for a parent or anybody to be able to read through those evaluations and be adequately prepared. You have the right to receive those evaluations before that meeting in sufficient time to be able to advocate for your child. The IEP meeting itself, you have the right to written notice 5 days in advance of the IEP meeting. I've had parents that get a call in the morning, of the day of the meeting. That's not adequate notice. That notice is to contain the purpose of the meeting, the date of the meeting, time and location, and who is going to attend the meeting. The parent has the notice provides an explanation to the parent that they have the right to participate in the IEP meeting and that they have the right to bring others to the meeting that they believe has knowledge and opinions that the parent thinks is valuable to the creation of this IEP for their child. For example, a child's outside therapist or doctor may have strong opinions that the child needs a particular behavioral modification program in school. They can appear by telephone, and the parent has the right to have them appear at that meeting. The IEP meeting, there's a mandatory composition of the meeting. That is, certain persons must be part of that meeting. Now, just to back up, the IEP meeting is the legally mandated venue where the development of the IEP actually takes place. And if whatever is wanted in that IEP is not raised at that meeting and it does not contain in the IEP, it's not legally enforceable provision that you can legally enforce. So it's at the IEP meeting that you want to raise the parent wants to raise all of their concerns. The parent and the IEP meeting participants, the mandatory participants are first the parent. A parent is a mandatory IEP team participant, which means that the district may not hold an IEP meeting without the parent receiving proper notice, the 5-day notice we just talked about, and at a time and they must provide the parent an opportunity to schedule the meeting at a mutually agreeable time. If you can't make it because you work during the day for a 10:30 meeting because you can't take off of work, which most of our parents can't, the Department of Education must hold it at a time that is mutually agreeable. The Department of Education may say to a parent, well, you can participate by telephone. I'll tell you, and it's best if you appear in person, and the school district must work with you to get it scheduled at a time that you can meaningfully participate in person. The school district can only hold an IEP meeting without a parent if the school avidly documents its efforts to get the parent to attend and its inability to persuade the parent to attend. So it's a very high standard that the district has to meet if a parent isn't present at that meeting. Other mandatory participants include the child's regular education teacher, the child's special education teacher, a school psychologist if there's a new evaluation that has to be interpreted, or a more restrictive placement is being recommended. And when I say more restrictive placement, I mean something more removed from the general education setting. The next more restrictive environment is what's called an inclusion class, which is a combination of special education and regular ed kids, to the more restrictive environments, such as a class of 12, then to a class of 8, class of 6, et cetera. And a district representative is also a mandatory member. A district representative is someone who knows all of the resources within the school district, so that if a parent says at an IEP meeting, my child needs applied behavioral analysis methodology in school, and the school psychologist at the school, or the IEP team at the school site says, well, our school doesn't have that, therefore it's not available. The district representative is supposed to represent the entire New York City school system, school district, and know that where that methodology can be obtained if it's available at all. And again, the purpose of the IEP meeting is to ensure a full analysis of who the child is, and by those who know him or her best, and what services and program services are available, that does that child need to make meaningful educational progress. At the meeting, the parent has the right to voice their concerns and have their concerns meaningfully considered by the IEP team. I would suggest, and as was stated earlier, prior to the meeting, I always advise parents, talk to your child's doctors. mental health professionals, anybody who works with the child outside of the school system who might have an opinion about what your child needs. And if they can provide a letter recommending a particular methodology, recommending a particular reading instruction, reading program, all of those things the parent has the right to provide to the IEP team participants, and the IEP team participants must meaningfully consider the parent's concerns. I would also recommend that parent compiles the couple days before the meeting, make a list, a laundry list of all the things you want to have said, because it's extremely important. You have the right to be heard at that meeting, but you want to make sure that everything that you have to say is stated at that meeting. As was suggested earlier, it's a great idea to for a parent to bring someone with her or him so that somebody else can take notes and the parent can really engage in that meeting. Because after all, what we're talking about is meaningful and active engagement. That's what the rights are all about, to provide a parent meaningful and active engagement in the development of their child's program. The parent has the legal right to understand the IEP process. The school district, in fact, must ensure that the parent understands the proceedings at the IEP meeting, including arranging for an interpreter for parents who may be hard of hearing or whose native language is other than English. The parent has the right to understand the acronyms. How many acronyms do we deal with in the IEP meetings and in our child's IEP? BIP. Behavioral Intervention Plan. What is that? FBA, Functional Behavioral Assessment. What's that? OT, LRE, FAPE, ESY. This is one area of law, I have to tell you, that has more acronyms than I've ever seen before. And so parents are just at sea in these meetings, and they have the right to speak up, to ask what these terms mean, but the DOE has a proactive responsibility to make sure that it's not Greek to the parent when they come in and to engage in that meeting. The parent has the right, as I stated earlier, to understand those evaluations, and the DOE should have a keen eye out to make sure that the parent does understand the evaluations, but parents know that you do have the right and you can demand that the evaluations be explained to you so that you understand them. Parents also have the right to advocate for, a child has the right to be in the least restrictive environment. What that means is, it's like the civil rights part of the statute. The school district may not remove your child from a general education setting or a less restrictive setting, like a general education setting, unless without appropriate supports and services, if the child cannot achieve meaningful progress with appropriate supports and services in the less restrictive environment, only then may they remove your child to a more restrictive environment. And that is a consideration that must be taken into account at the IEP meeting, and it's many times not. Oftentimes they will just go right to the most restrictive environment without discussion, and that's an important consideration, and there's a whole section in the IEP that speaks to that important consideration. And then, of course, the parent has the right, I say of course because it doesn't happen, has the right to receive a copy of the IEP in a timely fashion after the meeting. Oftentimes it is after the meeting because the IEP team needs to take into consideration everything and draft the IEP. Following the IEP meeting itself, the parent has the right to what's called prior written notice. And what prior written notice does is, prior to the Department of Education, I spoke earlier about the Department of Education. Let me know how I'm doing on my time.
You're doing so well that it's hard to cut you off.
Okay. Well, feel free. Okay. The school district cannot make any unilateral changes without the parent's agreement or a hearing officer's decision. So the parent has the right to receive a notice of the fact of before the school district initiates or changes or refuses to initiate or change the child's program. And that notice contains what the program recommendation is and the reasons why the Department of Education made those changes and what evaluations and materials the department relied upon. Okay. And And that's because it's important for parents to understand the reasoning to know whether to go forward and when and whether to go forward and challenge what the Department of Education has done. Finally, the participatory rights with respect to the school selection process. The parent has the right to timely notice of the school placement, not the day before school starts, not even 2 days before the school starts, but if a week or so. The point is that receiving notice of a school placement just days before the school year starts is not timely if it deprives the parent of information that he or she needs to evaluate the proposed school prior to the beginning of the school year. And then, and finally, the right to evaluate. In this right, the parent has the right to evaluate the school assignment, which means acquiring relevant and timely information about the proposed school. Can the proposed school implement the IEP, provide the related services, the sensory equipment, et cetera, that's contained in the IEP?
You've just had this, process of developing the IEP. You've gone to an IEP meeting. Now you have this document in your hand. And maybe a month or two later, down the road, you realize, well, actually something's missing here. Or, there was a service that I have on the IEP for my child, but it's not as frequent, like speech services. Like maybe they needed 2 individual sessions as opposed to just 1. So what can you do? So there's this process called reconvening the IEP team. So essentially, you're asking for a new IEP meeting. And you can do that literally at any time, after the IEP meeting has been held. So it could be the next day, it could be, 3 or 4 months later. But if, you believe that there have been if there's issues with the IEP as it's written, or if there has been changes that has happened to your child's, school and class situation, you can ask for a new IEP meeting. The way that you go about doing that is by, writing a letter to, the school. Typically, I tell my clients to write it to the school principal, asking for a new IEP meeting. This should be good for any student that attends a New York City community school, including a District 75 program. However, if your child attends a charter school or attends a private school or is homeschooled, then you need to write that letter to the Committee on Special Education for the area that you live in. So typically, once you write that letter, the school or the school district has 60 school days to reconvene the IEP team and develop a new IEP and go through that whole process that Laurie and Sandra had talked about just before. And at times, if you make that request and the school says, well, we're not going to meet again because we just held that meeting 2 months ago, or we just held that meeting a month ago, then you have a right to challenge that decision. So you can actually, and we're going to talk about this later on, you can go through the different steps that the law allows you to actually challenge their denial to reconvene the IEP team. So there is a separate process because the Congress back in 2004 realized, holding all these IEP meetings can actually be very time-consuming, and it's true. You have to bring, all these, school staff together. You also have to bring the parent together. So there's a separate process to actually make changes to the IEP if actually everyone agrees. So if the school officials, if the parent all agree that, Johnny needs that extra session of counseling, you can do something called amending the IEP. And essentially, you can make that request again, in writing to school officials, preferably the principal. And if they agree, then what will happen is that they will then send a letter to you, saying that we're going to amend the IEP because, we all agree that Johnny needs that extra session of counseling. Please sign here, and then you'll get your amended IEP. I also included here what to do if you want to change amend special education documents. So this is actually something a little different, and it is a little bit outside of the due process procedures that we're going to talk about later on. You can actually ask to change documents that have your child's name on it. So if, like, for instance, you disagree with what it says in an evaluation. So if there was an educational evaluation done on your child and it says that, he liked, playing with fire, and that actually is not true, and you want to have that changed, you have to go through a process that's outlined in Chancellor's Regulation A820, okay? So that process requires you to write a separate letter to the school, again, to the principal, asking them that, you would like this document to be amended, and you would highlight what it is that you want it, changed. And I'm not going to go into all the details there because you can go to the regulation. It's on the Department of Education website, because there's a process where the school may not agree to amend it, and then you have a process to appeal that. So, so those are the different options you have to either reconvene or amend IEP documents.
For my last question on the topic of rights associated with the IEP process, I'm going to bring it back to Lori. And Lori, could you tell us, do the rights or process associated with the IEP change at all based on a child's age?
So legally, no, the rights don't change because it's under IDA from 3 through 21, but different processes apply, as well as contingencies and variables at transition points. And by transition points, I mean from when a preschool student transitions from preschool to kindergarten, known as turning 5, when a student with an IEP applies to middle and high schools, there are different factors. And so for turning 5, again, the legal rights stay in place, and the federal law always supersedes whatever a school district does. Despite the size of New York City, we're still considered one school district. And for turning 5, it's incredibly arduous and convoluted because a parent of a child with a known disability and an IEP goes through 2 different processes simultaneously when applying to kindergarten. So they go through the process that all families go through when looking for kindergarten, and they also go through the process of developing a school-age IEP. So they still have to register for their for a seat at their local community school, as well as trigger the turning 5 process. And turning 5 is the cryptic code for going into kindergarten with a disability. And so parents will be contacted for a new evaluation, or they can ask for that to happen. It doesn't automatically happen. Back in the day, it did. Through the years, it's no longer required. And that could be a huge issue because when kids are younger, they change developmentally quicker. So what I mean by that is if a student at 15 or 16, and this is just an example, it doesn't apply to everybody, despite us being all about inclusion, it's not true. So a student who's 15 or 16, may choose to no longer focus on developing writing skills and may be evaluated for assistive technology to use a laptop, as opposed to a child who's 4 who is last evaluated when they were 2. There could be huge change. And so you don't want the team to use an evaluation that was done when they were 2, since the child has made a lot of progress. It can be very tricky when a student is known as a cleverly coined term twice exceptional, which means they have a high IQ and also could have behavioral problems. And so many times when we speak with parents, we ask them to think about the relationship of their child's behavior with learning and what that looks like and what kind of supports will help that child. And so, parents always have the right to ask for another meeting, to stop a meeting when it's happening, to ask for a break. And there's like soft things that can be done that we kind of don't talk about enough as parents.